Imagine you've lived on a piece of land for decades. You've paid the taxes, built a home, raised a family there. But in the eyes of the law, you might actually be a legal squatter.
Yeah, I know it sounds harsh, but
Yeah.
that really is the reality of land ownership in the Philippines.
Right, because unless you can prove otherwise, the state assumes it owns every single inch of dirt you're standing on.
Exactly. That's the Regalian Doctrine, or jura regalia, in action. It's the foundational principle we're digging into today.
And for this exploration into the source material, our mission is to look at how the rules of the game have radically changed. We're shifting from a period of nearly impossible strict compliance to a much more streamlined modern standard under Republic Act 173.
Yeah, we're using the 1987 Constitution, landmark Supreme Court cases like Republic VTA Properties, and the updated implementing rules and regulations of RA 11.1.3 to sort of map this out.
So let's unpack that default SETI first. If we look at the 1987 Constitution, specifically Section 2 of Article 12, it says all lands of the public domain belong to the state.
Right. State-owned until proven otherwise.
Which automatically puts you on the defensive from day one. You aren't just proving you bought it, you are proving the government doesn't own it.
And that burden of proof is incredibly heavy because most land is classified as inalienable, meaning it just can't be sold or owned privately.
But there is one exception.
Yes, agricultural lands. That is literally the only classification that can be moved into private ownership.
But for years, even if your land was agricultural, proving it was a total bureaucratic nightmare. The sources point to a strict era, highlighted by that 2008 case Republic VTA Properties.
That case created what was essentially a massive hurdle called the twin certification rule. To prove your land was alienable and disposable, or A&D, you needed two very specific things.
Right. First, an original classification from the government.
And second, a certificate from the local or provincial environment offices, the CNRO or PENRO, but here was the catch. That certificate had to be specifically approved by the DENR secretary themselves.
Think about that. You needed the signature of a cabinet-level official just to
prove your local plot of land was legal to own.
Exactly.
During this time, even a map from NAMRI wasn't enough. The Supreme Court basically ruled that without that secretary-level sign-off, your claim was just dead in the water.
It turned legitimate landowners into people with imperfect titles who just couldn't get over the finish line.
But this is where the major pivot happens, RA 11573. It recognized that the old system was just broken.
It completely dismantled that twin certification requirement. It took the power off the politician's desk and moved it down to the technical experts in the field.
The geodetic engineer. So instead of chasing down a secretary's signature, the law now says a certification from a DNR geodetic engineer is sufficient.
And they don't even need to draft a separate document. The certification is imprinted directly onto the approved survey plan.
As a sworn statement, the engineer just certifies the A&D status and cites the specific administrative order or proclamation that originally classified the land.
Exactly. It moves the goalpost from the cabinet level down to the technical level. But what if the records are messy? What if that original order is just gone?
The law actually includes a backup plan for that. If the original administrative order is missing, the engineer can instead reference the land classification map number and its release date.
Oh, wow. So it's a massive shift toward a substance over form approach.
It really is. And the final authority under the new IRR now rests with the chief of the Mapping and Survey Division of the Lands Management Bureau.
So reflecting on this whole transition, we've gone from the struggle of the twin certification rule to a highly practical, streamlined process. It's the difference between a massive legal headache and a confirmed title.
The underlying principle remains the same. The land is the state's until you prove it's yours. But RA 111573 finally makes that proof a logistical possibility.
Which brings us to a final provocative thought for you to explore on your own. If the law now accepts a map number and a geodetic engineer's stamp as enough to override the state's claim, does this represent a permanent softening of the Regalian Doctrine?
Or is this just a temporary window for those with imperfect titles to finally secure their legacy before the legal pendulum swings back towards strictness again?
That's something to think about. Thanks for joining us for this exploration into the source material.
All right, let's talk about something fascinating, land ownership in the Philippines. If you think you own a piece of land there, I've got a surprise for you. There's a core legal principle that might just flip your whole idea of ownership on its head. So let's dive into this, because it's a big deal.
So let me ask you this. When you're standing on your property, who really owns it? I mean, you'd probably say, I do, of course. I have the title. And that makes sense. But legally speaking, in the Philippines, the real answer starts somewhere else entirely. A much, much more powerful somewhere else.
And here's the big reveal. In the Philippines, the starting point, the default assumption is that all land belongs to the state. Yeah, you heard that right. Your private ownership, that's actually just an exception to the rule, a right that the state grants to you. And this one idea, this single concept, is the foundation for everything else we're going to talk about.
So this really powerful idea has a fancy legal name, the Regalian Doctrine. Seriously, it's the bedrock of all land law in the country. So let's unpack exactly what it means and, where it even came from. Okay, so the Regalian Doctrine, it's a legal concept we actually got from Spanish colonial times, and it lays down a really simple but kind of mind-blowing rule. All lands in the public domain belong to the state, period. That means the state is the ultimate source of any ownership rights. So if you want to say a piece of land is yours, the ball's in your court. The burden is completely on you to prove the state gave you that right.
And check out this quote from Justice Sanchez. It just nails the whole consequence of this doctrine. The standing presumption, as he calls it, is that land belongs to the state. Now think about what that really means. The government never has to prove it owns the land. You do. You're the one who has to show, without a doubt, that ownership was officially handed over to you.
And for decades, literally for decades, meeting that burden of proof was a total nightmare for regular folks. It wasn't just hard. It was like a legal obstacle course that most people just couldn't get through. So how in the world do you prove the state gave you that right? Well, first off, you can't just point to any piece of land and claim it. It has to be officially classified by the government as alienable and disposable. That's a mouthful, I know, but just think of it like the state putting a sign on the property that says, okay, this specific piece of land, we don't need it for public use anymore. It's now up for grabs for private ownership. And for the longest time, just proving that classification was the biggest hurdle you could imagine.
For a long, long time, the standard was set by this huge Supreme Court case, and it created something called the Twin Certification Rule. Sounds fun, right? It wasn't. To prove your land was actually available, you needed not one, but two separate documents. First, you had to get a certified true copy of the original land classification, and that had to be approved by the big boss, the Secretary of the DNR. Then, on top of that, you had to get another certificate from your local environment office, the CNRO or PENRO. And let me tell you, the courts were absolutely ruthless about this rule. I mean, imagine the frustration. You go to your local environment office, you do all the work, you get a certificate that says, yep, this land is alienable. You think you're good to go, right? Nope. That piece of paper was basically worthless on its own. If you didn't have that first, super high-level certification from the DNR Secretary's office in Manila, your application was just dead in the water. Game over.
So, as you can probably guess, this incredibly tough process created a gigantic backlog. We're talking about countless families who couldn't get a title for land they've lived on for generations. But, and this is the good part, a new law came along recently and just changed the whole game. It created a much, much simpler path to finally getting that title.
Just look at this side by side. It really shows you how huge this change is. The old way, over on the left, was just this tangled mess of bureaucracy, right? You're chasing down two different, super complicated documents. But the new way, thanks to Republic Act 11573, is so much cleaner. It's a straight line. It completely throws out that old twin certification rule and replaces it with one single elegant requirement.
So what's this new proof actually look like? Well, it's just one single certification. It's signed by a designated geodetic engineer from the DENR. But here's the really clever part, the genius of it. It's not some separate piece of paper you can lose or damage. It's physically imprinted right onto the official survey plan of your land. And that little stamp, that imprint, contains everything you need, a sworn statement, and it even cites the specific government orders that made the land available in the first place.
And that right there is the heart of the whole reform. The process went from this crazy, difficult hunt for two separate documents down to just one. That's it. A single official certification is now all the proof you need. I mean, in terms of bureaucracy, that is a revolutionary change in its simplicity. Now I get it. You might be hearing these terms like geodetic engineer or forestry administrative order and thinking, that still sounds pretty complicated. But here's the thing. The legal experts who wrote the rules for this new law basically said, don't worry. The actual process for you on the ground is designed to be way more straightforward. All the forms, all the statements, they've been standardized and simplified.
Okay, so we've waded through some of the legal jargon, but why does any of this actually matter? What's the big deal? Well, this isn't just some abstract change on paper. It has a real, profound impact on the lives of so many everyday Filipinos. This table really lays it all out, nice and clean. Just look at the old rule on the left. Multiple documents, multiple offices, just high complexity. It was a mess. Now look at the new rule on the right. It simplifies every single thing. One piece of evidence, one clear authority, an integrated format. And that bottom line says it all. Complexity went from high to low. This wasn't an accident. It was a deliberate choice to cut through the bureaucracy and make this whole thing accessible for the average person. So, at the end of the day, this is about so much more than just a legal tweak. It's about empowerment. This new law finally gives families a clear, and more importantly, an achievable path to getting a real legal title for the land they've called home, sometimes for generations. It just slices through all that red tape, removes this huge barrier, and turns decades of uncertainty into real security. And that really leaves us with one final big question to think about. When you make it this much easier for people to prove they own their land, you're not just handing out pieces of paper. You're unlocking economic potential. You're providing families with security. You're changing the entire relationship people have with the land they live on. So the real question is, what are the long-term ripple effects of this going to be? It's a huge shift, and I think its full impact is something we're only going to see unfold over the coming years.
I want you to close your eyes for a second. Well, maybe don't close them if you're driving right now.
Yeah, please keep your eyes on the road.
Right. But if you can just imagine this scenario for me. It is a Saturday morning. The sun is just coming up.
The best time of day.
Right, exactly. You walk out your back door, you've got a coffee mug in your hand, and there's steam rising off the top of it. You step onto the grass. You can feel the dew on your slippers.
Painting quite the picture here.
I'm trying to. So you look at the fence line, the one that separates your yard from the neighbor's yard.
Yeah.
You look at the garden you planted last spring. Maybe the tomatoes are finally coming in.
Oh, yeah.
And then you turn and look back at the house itself. And standing there, you feel this this immense sense of solidity.
Absolutely.
Because this is yours. You bought it. Or maybe your parents worked their whole lives to leave it to you. It feels absolute. It feels permanent.
It is a very grounding feeling, literally and figuratively. I mean, we build our lives, our identities, our financial security on that specific patch of earth. It is the ultimate dream, really. A title, a lot, a home.
Right. It is the ultimate safety net. But, and here is where I unfortunately have to shatter that Saturday morning piece.
Oh.
What if I told you that under the law, that solidity might be a complete illusion?
A total mirage in some cases.
Yeah, that the ground beneath your feet, despite the fence and despite the house and despite the mortgage you've been paying for 15 years, that it might actually be presumed to belong to someone else entirely.
And we should clarify that by someone else, we aren't talking about a long-lost cousin who suddenly shows up.
Right.
Or a bank with a foreclosure notice. We are talking about the state itself. The Republic of the Philippines.
I know it sounds like a conspiracy theory, doesn't it? Like something you would read on a dark corner of the internet. You know the government secretly owns your backyard.
It does have that flavor.
But it isn't a theory. It is actually the foundational legal principle of land ownership in this country. It is this silent battle between what you think you own and the state's default dominion over every single square inch of the archipelago.
And that is exactly the core tension we are attacking today. It is this massive and often deeply misunderstood gap between possession, which is just physically sitting on the land, and ownership.
Because ownership is a whole different beast.
Completely different. Ownership is a legal fortress that you have to build stone by stone, or rather document by document.
And that is our mission for this deep dive. We are going to navigate the absolutely massive, complex legal maze of land ownership in the Philippines.
And we aren't just talking about the modern process of buying a condo from a developer. That's a different topic.
Right, that's mostly contract law. We're talking about the root of the title itself.
Yeah.
How do you legally prove that a piece of land is no longer government property?
Which, as you see from the sources, is the actual legal question at play.
Yeah, because as I learned from the stack of research we're looking at today, it's not simply, do I own this? The court doesn't ask that. The court asks, did the government ever actually release this?
Precisely. And that distinction changes everything about how you fight for your land in court. It flips the script entirely.
So to guide us on this journey, we have pulled from some really heavy hitter sources today. We're looking at a deep legal review of land registration laws. We've got specific Supreme Court jurisprudence, stare decisis, the whole 9 yards.
The foundational cases that built the system.
Exactly. And we also have some very significant legislative updates, specifically Republic Act 115073.
Which really shook things up.
It really did. And before we dive right in, I want to be clear that we are looking at these documents purely to understand the legal mechanics. We are just imparting the facts as they are written in the jurisprudence and the statutes.
Just analyzing the law as it stands.
Right. So just to give you listening at home a quick roadmap so you don't get lost in all the legalese. First, we are going to start way back in the day with the ancient doctrines that give the state this ownership superpower to begin with.
The historical context is crucial here.
Then we are going to look at what I am calling the twin certification nightmare.
Oh, it was an absolute nightmare. That is the period roughly from 2008 to 2021 where proving ownership became nearly impossible for the average person.
Yeah, it seems like a time when the Supreme Court tightened the screws so hard that completely legitimate owners were losing their land on technicalities.
It was a very dark time for land registration applications.
And then finally, we are going to arrive at what our sources are calling the game changer. That 2021 law that completely overhauled the evidence you need to prove the land is yours.
Moving from ancient Spanish rules to modern bureaucratic simplifications.
But simple doesn't always mean easy, right?
Oh, definitely not. It just means the rules are clearer. You still have to do the work.
So let's unpack this. Let's start at the very beginning. The Regalian Doctrine. I have to say, it sounds like something straight out of a fantasy novel. Jura Regalia. It sounds like a magic spell.
It does have a very medieval ring to it, doesn't it? And that is actually completely appropriate because the concept isn't originally Filipino. It was imported.
Imported by who?
It was introduced from the West by Spain during the conquest.
So this goes back to the conquistadors. We were talking Magellan, Legazpi, that whole era.
We are talking about the laws of the Indies and the royal cedulus. To really wrap your head around this, you have to understand the mindset of the 16th century European colonial powers.
Okay, put me in that mindset.
When Spain discovered, and I use that term loosely, and conquered the archipelago, they didn't just view it as gaining political control over the local populations.
Like just becoming the new government.
Right. It wasn't just administrative. The legal theory of the time was that the king himself, the crown, acquired the actual title to the soil itself.
So physically, the King of Spain owned the literal dirt.
It's everything. The land, the natural resources, the minerals, the forests, the waters, all of it instantly became the private property of the crown by right of conquest.
That is wild.
This is the absolute feudal origin of our modern land laws.
So if you were a local chieftain or just a farmer living there, cultivating rice on the same land your ancestors had occupied for 1,000 years, suddenly legally you didn't own it anymore.
Not in the eyes of the new European legal system, no. Jura Regalia translates literally to royal rights.
Royal right.
The king held the title to the entire conquest. So if a private person owned anything, it was only because the king benevolently granted it to them.
Like a gift.
Exactly. Or later on, the state granting it. It is a completely top-down approach to property. You are essentially a tenant on the king's land until the landlord explicitly gives you a deed.
Okay, but here's where I get a little tripped up. We kicked the Spanish out in 1898.
We did.
Then the Americans came, then the Japanese, then we finally got full independence. Why on earth are we still talking about royal rights today? Why didn't the founders just scrap that entire concept and say, hey, if you live here, it's yours?
It's a fair question, but legal systems are incredibly sticky. They evolve, sure, but they don't usually reboot from scratch because that creates chaos.
So they just kept the king's rules.
Essentially, yes. When the Philippines became a republic, the new state simply stepped into the shoes of the Spanish king. The concept of the crown was simply replaced by the concept of the public domain. If you look at the 1987 Constitution today, specifically Section 2 of Article 12, it is written right there, the doctrine did not go away.
Let me actually read that text because I have it pulled up in our source notes and it's pretty striking. It says, quote, all lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all forces of potential energy fisheries, forests, or timber wildlife, flora and fauna, and other natural resources are owned by the state, unquote.
Owned by the state. That is the anchor right there. That is the constitutional mandate.
It's extremely comprehensive. They threw everything in there.
They really did. The state is considered the ultimate source of property rights. Think of it like a fountainhead.
Okay.
The state is the source of any asserted right to ownership. So if you stand in court and say, I own this, the law essentially hears the state gave me permission to own this.
Wow. Okay, so if the state is the default owner of absolutely everything, that fundamentally changes the burden of proof in a courtroom, doesn't it?
It flips it entirely on its head.
Because usually if someone claims my stuff, let's say they claim the watch on my wrist, they have to prove it's theirs. I am possessing it, so the law assumes it's mine until they prove otherwise.
Correct. In regular civil law, possession is usually 9/10 of the law.
Right.
But with land, throw that completely out the window. It is not the state's job to prove it owns the land you are standing on. It is your job to prove the state doesn't own it.
That is a massive shift in perspective.
Yeah.
It means the starting line is 100 meters behind where I thought it was.
Exactly. You are starting at a deficit. There is a very famous quote from Justice Sanchez that sums this up perfectly, and you will see it cited in almost every major land registration case in the Philippines.
What's the quote?
He said, quote, "The standing presumption we must not forget is that land pertains to the state," unquote.
Land pertains to the state. It sounds so passive on the surface, but functionally, it's incredibly aggressive.
It is legally devastating if you aren't prepared for it. It means if there is a tie in the evidence, the state wins. If your paperwork is a little blurry, the state wins. If the municipal records were lost in a fire, the state wins. You have to decisively overcome that standing presumption.
The burden is entirely on the citizen.
Exactly. The jurisprudence says you have to conclusively show ownership. The standard of proof is incontrovertible evidence.
Incontrovertible. That means undeniable. Not just pretty good evidence. Not just, hey, my neighbors have seen my family living here since the 70s.
Right. Anecdotes won't cut it. And this is where we really have to get into the classification of lands. Because under this system, not all dirt is created equal.
Okay, lay out the classifications for me. How does the Constitution break it down?
Well, the general rule is that natural resources cannot be alienated.
Alienated, let's define that because it's a specific legal term. It doesn't mean making the land feel lonely and isolated.
No, it doesn't. To alienate in property law simply means to transfer ownership. To sell it, to give it away, to allow a private person to hold the title. So, most land in the country, things like forests, timberland, mineral reserves, national parks, is strictly inalienable. The state keeps it forever. You can never, ever get a private title to a forest.
So wait, if I go out and build a house in the middle of a designated forest, no matter how long I live there, no matter if I'm there for 50 years and plant an orchard,
you will never own it. Legally speaking, you are just a squatter on the public domain.
even if I pay the local taxes.
It doesn't matter if you pay real property taxes on the house you built. It doesn't matter if you have a local electricity bill in your name. The land itself is beyond the commerce of man. It cannot be owned by you.
Okay, that is pretty severe. So what type of land can I actually own?
The exception, and it is the only exception under the Constitution, is agricultural lands of the public domain.
Just agricultural.
Yes, those are the only lands that are allowed to be classified as alienable. So step one in owning land is that it has to be agricultural in its nature. And then step two is the big one. The government must have explicitly said, this specific piece of agricultural land is now available for private ownership.
So just to summarize, the default status of any given piece of dirt in the country is inalienable public domain until the state actively says otherwise.
That is the absolute baseline. Unless you have hard proof to the contrary, the law looks at your backyard and assumes you are sitting on government property.
Okay, that is heavy. So let's get practical for a second. Let's say I'm a landowner, or I think I am. I want to sell my land, or maybe I want to use it to get a bank loan to start a business. The bank wants a title. How do I actually break away from this standing presumption? How do I prove to a judge that the state let this specific piece of land go?
You need to show what the courts call a positive act.
A positive act, meaning the government didn't just forget about the land or ignore me living there, but they actively did something to release it.
Precisely. Silence from the government is not permission. Tolerance is not permission. They have to speak. And when the government speaks, they speak through official high-level documents.
What kind of documents are we talking about here? Give me some examples of a positive act.
We are looking for things like presidential proclamations, executive orders issued by the president, legislative acts, which are statutes passed by Congress.
So big national level decrees.
Yes. Or in some specific cases, administrative actions like investigation reports by the Bureau of Lands, but those have to be formally approved by the department secretary.
Okay, so I essentially need a national paper trail.
Yeah.
But this is where it gets really messy in reality, right?
Yeah.
Because I feel like a lot of regular people think, hey, I have a tax declaration, or I have a certificate from the local city hall. I mean, I pay my amelior, my real property tax every single year. The city treasurer gladly takes my money.
Oh, they will always take your money.
Right. So doesn't the fact that they tax me prove that the government acknowledges I own the land?
You would certainly think so. It seems perfectly logical. If you tax me, you accept I am the owner.
Right.
But the Supreme Court has ruled time and time again that tax declarations are not conclusive proof of ownership. Yes. They're considered proof of possession in the concept of an owner, which means they are good supporting evidence. They show you are acting like the owner. But they are absolutely not the positive act that breaks the Regalian Doctrine.
Because the city treasurer isn't the one who decides what is public domain.
Exactly. The city treasurer taking your tax payment is not the legal equivalent of the president of the Philippines releasing the land from the public domain. They are two totally different mechanisms.
That has got to be a heartbreaking distinction for a lot of people to learn in court.
It is devastating. And the initial confusion for decades, honestly, was that applicants thought getting a simple certificate from a local land officer was enough to prove the positive act.
So how would that work? You just walk into the local office?
Yeah, you would go to the local branch of the DNR, the CNRO.
We define CNO for the listeners real quick.
That is the Community Environment and Natural Resources Office. It's the local boots on the ground for the department.
Okay, got it.
So you walk in there and you ask them for a certification that your land is alienable and disposable. They look at their local maps. They say, yes, this area is clear. They print you out a certificate, sign it, and you walk out thinking you are golden.
Because a government official just gave you a signed paper saying the land is clear.
Exactly. It feels official.
But you're telling me you're not golden.
Well, for a long time, it was a gray area in the lower courts. But then came the era of strict compliance. And this whole era centers around a major conflict in the case law regarding who actually has the legal authority to certify that land has been released.
Which brings us perfectly to Section 3 of our outline. The villain of the story, so to speak. Or maybe just the really strict principal who fails the entire class over a technicality.
That's a good way to put it.
I am talking about the case of Republic VTAN properties.
Yes. This is the landmark case. If you operate anywhere in the real estate or legal world in the Philippines, the TAM properties case, it was an absolute watershed moment.
So paint the picture for us. What actually happened in this case? Who or what is TAN?
TAN Properties, Inc. is a corporation, and they applied for the judicial registration of a pretty significant chunk of land. We are talking about 56 hectares in Sto Tomas, Batangas.
56 hectares. Okay, so this wasn't just somebody trying to register a small backyard garden. This was a major commercial development.
Oh, absolutely. It was a massive tract of land.
So they obviously had lawyers. They had resources to put into this application.
They did. And to prove that the land was alienable and disposable, which the industry calls A&D for short, they submitted what pretty much everyone submitted back then. They submitted a certification from the CNRO.
The local office we just talked about.
Yes. In fact,
Yeah.
They had certifications from both the Provincial Environment and Natural Resources Office, the PNRO and the CNRO. Both of them certified that the 56 hectares were A&D land.
Okay, sounds solid.
Right. And the trial court looked at those certificates and said, okay, this looks good to us, application approved. Then the Republic appealed it to the Court of Appeals. The Court of Appeals looked at it and said, affirmed, register the title.
So the corporation won. 2 courts agreed with them.
They won at the first 2 levels, yes. But then the Republic, represented by the Office of the Solicitor General, elevated the case all the way to the Supreme Court. And the Supreme Court completely flipped the table.
Why, though? If the local environmental office says the land is A&D, why would the highest court in the land reject that?
Because it all goes back to that hierarchy of authority we talked about earlier. The court asked a very fundamental question here. Who actually has the power by law to release land from the public domain? Is it the local senior officer sitting in Batangas? Or is it the secretary of the DENR and the president of the Philippines?
And the answer legally under the Regalian Doctrine has to be the big bosses.
Exactly. Under the Public Land Act, only the secretary or the president has the delegated power to classify land. The local senior officer does not have that power. Their job is to enforce the rules locally not to change the permanent classification of the national territory.
I see. So the local officer was issuing a certificate about something they didn't technically have the authority to declare on their own.
Well, the local officers were certifying a fact. They were saying, based on our local records, this land is A and D.
Right.
But the Supreme Court said that a simple factual certificate from a local officer isn't actual proof of the original positive act. It is kind of like hearsay in a bureaucratic sense.
Hearsay.
Yeah. The court essentially said, we don't want to hear from the messenger. We want to see the original letter from the king. We want to see the exact moment the state released this land.
Wow. So this ruling birthed what our sources called the twin certification requirement. And just reading about this in the notes, it sounds like a bureaucratic hurdle from hell.
It truly was. The court laid down a new, incredibly strict rule. They ruled that to conclusively prove ownership from that point forward, you needed two very specific separate documents.
Okay, what's document number one?
Number one is a copy of the original classification approved by the DNR secretary or the president.
A copy of the actual historical order, like a piece of paper that says Forestry Administrative Order number 411157 dated 1952.
Yes, exactly that. And it couldn't just be any copy. It had to be certified as a true copy by the official legal custodian of the records.
So you couldn't just bring in a grainy photocopy you found in your grandfather's desk.
Absolutely not. You had to physically go to the Central Archives in Manila or wherever the records division was and get an official stamped true copy of a document that might be 50 or 60 years old.
That's already a huge burden. What was document number two?
Number two was the status certificate. This is the one issued by the local Senro or Penro.
The one everyone was already getting.
Right. But here is the massive catch. That local certificate now had to explicitly state that it was based on the specific classification approved by the DENR secretary.
So you needed the local paper saying this land is clear locally, A&D. You needed the national paper saying, I, have the secretary, authorized this land to be clear nationally, A&D. They had to cross-reference each other perfectly.
Exactly. Twin certifications, they had to mirror each other.
Why did the Supreme Court make it so unbelievably strict? It seems almost punitive.
You have to look at it from the court's perspective. They realize that local officers are great at verifying surveys and boundaries, but they are not the ones who make national land policy.
Right.
And if a local officer makes a mistake, or frankly worse, if a local officer is bribed and issues a clear certificate for what is actually protected forest land, the state permanently loses a vital national resource.
So it was an anti-corruption and preservation measure.
Very much so. The Supreme Court wanted to aggressively protect the Regalian Doctrine. A local certificate without the underlying high-level approval backing it up is, legally speaking, empty. It's a house built on sand.
Practically speaking, I mean, just imagine you are a regular farmer. You live in a rural province miles and miles away from Manila. You don't have a team of corporate lawyers like TAN Properties did.
It's a completely different reality.
You are telling me that if that farmer wanted to finally get a title for his grandmother's farm so he could pass it to his kids, he had to personally dig up an original administrative order from maybe 1930.
Yes, that was the law. And not just find it, but navigate the central bureaucracy to get it certified. It was a massive, often insurmountable hurdle.
I can imagine.
Many of these original orders were ancient. They were typewritten on fragile onion skin paper. Some of them were lost in fires during the war. Some were destroyed by floods or eaten by termites in poorly funded local archives.
So what happened if the document was just gone? I can imagine thousands of applications just died right there on the spot. Sorry, sir, we can't find the forestry order from 1955, so you lose your family land.
That is exactly what happened in many cases. It created a massive bottleneck in the judicial system. The standard of proof was raised so high that totally legitimate owners, people whose families had been openly and peacefully occupying the land for generations, couldn't clear the bar.
It created a whole class of what the sources call imperfect titles.
Yes, imperfect titles. It is a terrible limbo state to be in.
Because you are physically on the land, but you can't bank on it. You can't use it as collateral to send your kids to college.
And from a macro perspective, it severely stifles economic development. Dead capital, as economists call it.
But wait, surely the courts eventually realized this strict standard was becoming impossible.
Yeah.
Right? I mean, were there any exceptions at all? If I could prove I've been farming the land since before World War II, did they cut me some slack?
That leads us perfectly into the era that the sources identify as the confusion. Because yes, there were instances where the courts recognized the sheer practical impossibility of what they were asking. We call these the pro hac vice rulings.
Pro hac vice, that is Latin, right? What does that translate to?
It translates roughly to for this occasion only, or for this particular case.
Okay. So it's the legal equivalent of a cop pulling you over and saying, I'll let you out for the warning this time, but don't ever do it again.
That is a very apt analogy. The Supreme Court is saying we are making an exception here, but do not treat this as the new rule. We look at cases in our sources like Republic v. Vega and Republic v. Serrano.
What happened in those?
In those specific cases, the courts actually allowed the applicants to win and register their land without strict adherence to the twin certifications.
Oh, wow. So they let them slide with just the local CNRO certificate.
Essentially, yes. The court accepted what they called substantial compliance rather than strict compliance.
But here's the catch, I assume.
It is a massive catch. These pro-hack vice rulings did not overturn the TAM properties precedent. The court was very explicit about that. They said, we are only letting this slide because of the timeline of the application.
The timeline. What does the calendar have to do with the validity of land title?
It has to do with fairness and due process. The TAN properties decision was officially promulgated on June 26, 2008.
Okay.
The Supreme Court reasoned that if a lower trial court had already heard and decided a land registration case before that specific date, the applicant couldn't possibly have known about the new stricter twin certification rules.
Oh, I see. Because they filed their case under the old understanding of the law. You can't change the rules of the game in the bottom of the ninth inning.
Exactly. Stare decisis, the principle of following legal precedent, means that rules should be stable and predictable. So if your case was decided by the trial court before June 2008, you might get a pass based on equity.
But if you filed your case in July 2008...
Strict compliance, twin certifications, no mercy whatsoever.
That is incredibly tough. It essentially means that your fundamental property rights depended entirely on when your lawyer happened to file the paperwork, not on the actual historical reality of land itself.
It is a harsh reality of procedural law, and it caused immense confusion because lawyers would cite the Vega case trying to get their clients an exception, and the judges would have to say, no, that was pro-hack vice, your timeline doesn't fit.
Just a mess. Now, while we're in this era of confusion, I saw you highlighted a whole section in the research notes about an agency called NNMRIA.
Yes, the NMRA problem.
The National Mapping and Resource Information Authority. I love maps. I'm a map nerd. And I feel like if there is an official government agency completely dedicated to mapping the topography of the Philippines, their word should be gospel. Surely an official map from NMRIA is good enough evidence for the court.
You would think so, wouldn't you? And many applicants tried exactly that strategy.
It makes sense.
They would go to NAMRIA and they would request a certification saying, according to your official government maps, is my plot of land alienable and disposable? NAMRA would look at the map, issue a certificate, and the applicant would take that to court.
And what does the Supreme Court say to that?
The court rejected it completely.
Why? They are the official mapping authority. It is literally in their name.
They are the mapping authority. They're not the classification authority. And in land law, that is a subtle but absolutely lethal distinction.
Unpack that for me.
The Supreme Court ruled that NAMRA is not among the agencies authorized by law to actually certify land classification. Their job is simply to draw the lines that the DENR tells them to draw.
Oh. So they're the draftsmen, not the architects.
Exactly. That's a perfect way to put it. They visualize the law, but they do not create the law.
So bringing an NARIO certificate to court under the strict rules was just useless.
As independent proof of classification under the TAN doctrine, yes, it was useless. The court said NAMRIA lacked the statutory authority to issue a valid copy of the classification. However, and this is a very important nuance that we will come back to in a minute, the court did acknowledge that the NAMRIA maps themselves are highly authoritative if they are backed up by the proper executive or legislative orders.
Okay, so the map is basically a picture of the law, but it cannot replace the text of the law itself.
Correct. You still needed the underlying positive act.
This is getting so incredibly technical. I can totally see why ordinary people just gave up and resigned themselves to having imperfect titles.
It was exhausting.
You have the state presuming it owns your living room. You have the Supreme Court demanding a specific, fragile piece of paper from the secretary that might be lost in a flooded basement somewhere in Manila. You have the National Mapping Agency trying to help you, but getting shut down by the judges. It really feels like the entire system was just completely broken.
It was clogging the judicial dockets, it was deeply frustrating citizens, and frankly, from a governance perspective, it was highly inefficient. You had highly trained judges spending hours analyzing whether a 50-year-old photocopy of an administrative order was legally authentic. It was not a good use of anyone's time.
And finally, the game changer.
Yes. Enter Republic Act 173, passed in 2021.
This is Section 5 of our outline. The relief. The cavalry finally arriving over the hill to save the day. What exactly did this new law do?
The explicit goal of RA 11573 was to simplify the judicial confirmation of imperfect titles. The legislature Congress finally looked at the massive bureaucratic mess created by the TAN property's strict compliance doctrine and said, okay, we need to fix this legislatively. We need to unclog the system.
So does the new law kill the twin certification requirement completely?
Effectively, yes. It steps in and replaces the old impossible form of twin certifications with a new system that is much more manageable for the citizen, but is still legally robust enough to protect the state.
Okay, so what is the new standard of proof? What is the new golden ticket you need to win your case?
Under Section 7 of RA 11573, the core requirement is no longer chasing down certified true copies from the Central Archives. The requirement is now a duly signed certification by a designated DENR geodetic engineer.
A geodetic engineer. That is the professional who actually goes out with the tripods and physically measures the land boundaries right.
Correct, the land surveyors. But here's the really brilliant part of the new law. This certification from the engineer isn't just another separate loose piece of paper that you have to carry around in a folder and hope you don't lose.
Okay, where is it then?
The law mandates that this certification must be imprinted directly onto the approved survey plan of the land itself.
Oh, wow. That is incredibly smart. So the legal proof of the land's status is literally stamped right onto the physical map of the land boundaries.
Exactly. It consolidates the evidence into one master document. When you or your lawyer submit your official survey plan to the judge, the proof of classification is staring right at them on the face of the document. You don't need a separate folder for the administrative order.
But what does this imprint actually say? Is it just a generic rubber stamp that says approved, or this is okay?
No, it has to be highly specific to satisfy the courts. It contains a formal sworn statement by the geodetic engineer.
Sworn under oath.
Yes, and it must clearly declare that the specific land surveyed is alienable and disposable agricultural land.
Okay.
But, and this is how the law brilliantly preserves the old Regalian Doctrine, the statement must still explicitly cite the historical references.
Ah, so it still needs to point back to the original Positive Act. It doesn't erase the history.
Exactly. It must cite the specific Forestry Administrative Order or DENR Administrative Order, Executive Order, or proclamation that originally released the land. And this is absolutely crucial for the new system. It must cite the Land Classification Project map number, the LC map number.
So if I am understanding this correctly, instead of me, the regular farmer, having to spend months traveling to Manila to find the original 1955 Forestry Administrative Order, the professional geodetic engineer looks it up in their internal system, cites the specific numbers on the survey plan, swears to it under penalty of perjury, and that is now enough for the judge.
That is the beauty of the reform. It shifts the massive burden of locating and authenticating the bureaucratic history. It moves that burden away from the ordinary citizen and places it onto the professional geodetic engineer and the internal DENR record-keeping system. The engineer validates the historical data for the court.
That is a staggering improvement. It still completely respects the state's ultimate ownership because you still fundamentally need that underlying order to exist, but it makes the process of proving it so much more humane.
It finally bridges the gap between the abstract strictness of the law and the practical reality of being a citizen.
But I do have a very practical question here. We talked extensively earlier about lost records, the typhoons, the fires, the poorly maintained archives.
Right.
What happens if the geodetic engineer goes into the DENR archives to do their research for the imprint and they can't find the actual text of the original order? What if the physical piece of paper containing the Positive Act is still missing, even for the professionals? Does the application still fail?
That is where the law introduces what we call the safety valve. This brings us to Section 6 of our discussion, and honestly, it is my absolute favorite part of RA 11573, because it shows that the lawmakers were actually thinking about the messy reality of the Philippines.
Because in a country with our history of disasters, records just get lost. It is inevitable.
Exactly. It is a fact of life. So RA 1153 includes a highly specific safety provision for exactly that scenario. If there is no available copy of the original Forestry Administrative Order or Executive Order, the The law says it is legally sufficient to state the LC map number, the project number, and the date of release in the sworn statement.
Wait, hold on. Let me make sure I'm fully understanding the magnitude of this. If the actual typewritten text of the old order is completely gone, turned to dust, but the map number still exists in the registry, that alone is enough.
Yes, that is enough. The underlying legal logic here is that if an official LC map number and a release date exist in the system, it conclusively confirms that the map exists in the NAMRA inventory and is actively being used by the DNR.
I see.
Therefore, the mere existence of the official map implies the historical existence of the original order. The government wouldn't have numbered and dated a map for an order that never happened.
Oh my goodness, that totally validates NAMRA.
It absolutely does. Remember how we talked about how NARA couldn't independently certify classification under the old strict rules?
Yeah, they got shut down by the Supreme Court.
Well, now through the mechanism of the geodetic engineer formally citing the NARA map data directly on the survey plan, that geographical information becomes fully admissible and conclusive in court. The map essentially becomes the legal proxy for the missing order.
That is huge.
Yeah.
I mean, think about it. That safety valve probably saves thousands of land applications that would have automatically failed under the old rules just because a piece of paper disintegrated in a warehouse somewhere in 1975.
It really does save them. It legally accepts the reality that government record-keeping over the span of a century isn't perfect. And more importantly, it finally stops punishing the innocent citizen for the government's failure to preserve its own archives.
It's a huge shift in empathy from the legal system.
Yeah.
So how does this actually work in daily practice now? Who exactly signs this imprinted certification? Is it just any private engineer I hire off the street?
No, the implementing rules and regulations, the IRR of the law, clarify that to maintain security, it is not just the private geodetic engineer you hire to measure your fence.
That makes sense. That would be too easy to fake.
Right. The survey plan must ultimately be approved by the Land Management Bureau, the LMB. Specifically, it goes through their mapping and survey division. The chief of that specific division is the one who acts as the authorized geodetic engineer for the final approval and signature on the imprint.
So it still goes to the very top of the technical division to ensure accuracy.
Yes, it does. And as one of our sources notes, and I love this quote, although this may sound complicated, it is not, unquote.
Compared to the twin certifications, it sounds like a walk in the park.
Exactly. The deeply daunting twin certifications are completely replaced by standardized, very simple statements imprinted directly on the survey plan itself.
It is kind of like moving from writing a handwritten letter that takes 3 weeks to mail and authenticate to just checking a verified box on a secure digital form.
That is a great comparison. It completely streamlines the judicial process without actually abandoning the core constitutional principle. The state still theoretically owns the land until that specific box is checked and verified by the chief of the division.
This whole journey has been a really fascinating evolution of law. Let's try to synthesize all of this for the listener who has stuck with us through all the legalese.
Let's do a quick recap.
We started way back with the Regalian Doctrine.
The feudal idea that the king owns all. The modern state is the default owner of the archipelago, and therefore the burden of proof is always entirely on you, the citizen.
Then we moved into the Dark Ages, the era of strict compliance.
Initiated by Republic VTA and properties. That was the era where you desperately needed the twin certifications. The DNR secretary had to personally sign off in the archives. And if that fragile piece of paper was lost to history, you simply lost your land.
And finally, we arrive in the modern era with the passage of RA 11573.
Where the whole evidentiary process is professionalized, the geodetic engineer certifies the legal status directly on the survey plan itself. And the simple LC map number can save your entire case if the original order is missing from the vaults. It is vastly more efficient, but it still fundamentally respects the jura regalia.
It really shows how legislation has to eventually evolve to meet reality. I mean, the law finally realized that asking for impossible paperwork was actively hindering legitimate private ownership. It was hurting the local economy, it was hurting regular families, so Congress fixed the procedural process without having to break the underlying constitutional doctrine.
And that right there is the delicate balance of a functioning legal system, protecting the state's patrimony, its vital natural resources, while simultaneously allowing ordinary citizens to actually have legal security and peace of mind in their own homes.
It is a great balance. But you know, even with this amazing new law and all these modern simplifications, I still just cannot shake that feeling I had from the intro.
The illusion of solidity.
Yeah, the idea that ownership at its very core is conditional.
It absolutely is conditional.
Yeah.
And honestly, here is a final provocative thought for everyone listening out there. Even with RA 11573 making the paperwork easier, the fundamental burden still remains on you. The absolute default setting of the earth beneath your feet right now is that it belongs to the collective. It belongs to the state. True private ownership is the exception. It is not the rule.
That is such a wild way to think about the physical world around us.
Yeah.
Because day to day, we just assume everything is private property unless it has a sign that says public park. But the Constitution essentially says everything is a public park unless you have the exact right documents to prove it's private property.
Precisely. And if we really push that logic to the limit, if the government suddenly scrutinized every single title in the country today, if they tested every presumed owner against the strict historical origins of the Regalian Doctrine.
Oh, well.
How many people out there right now own land today that would actually legally revert to the government if it was formally challenged? How many beautiful fences and houses are currently standing on land that, legally speaking, is still the king's untouched forest?
That is a thought that will definitely keep me up at night.
It really should make you want to go double-check your survey plan. Look for that specific imprint. Look for the LC map number.
Absolutely. So to everyone listening, go find your land titles. Dig them out of the safe. Look at them with fresh eyes, knowing what you know now. See if you can actually find the trace of that positive act that makes that piece of earth legally yours.
Because without it, you are just a long-term guest on the state's land. And the landlord can technically always ask for the keys back.
On that very cheery existential note, thank you for joining us on this deep dive into the ground beneath your feet. We will catch you on the next one.
Stay curious and please verify your documents.
See ya.
Welcome to the debate. Today, we are looking at the literal ground beneath our feet. We are examining the Regalian Doctrine, or Jura Regalia. It is the fundamental legal philosophy which posits a rather startling reality. All land belongs to the state unless you can prove with absolute certainty that it doesn't.
Right.
And it is a concept deeply rooted in history, dating back to the Spanish laws of the Indies. Yet it remains the absolute bedrock of property law in the Philippines today.
It is. And, it is a bedrock that has, quite frankly, crushed many legitimate property owners under its weight over the years. While I understand the historical context, the King of Spain owning the archipelago, the modern application of this doctrine has evolved into, a bureaucratic labyrinth.
A labyrinth, yes, but a necessary one, I would argue.
But we are looking at a system where the presumption of state ownership places a burden of proof on individuals that is often mathematically impossible to meet. I mean, we aren't just talking about legal theory here. We are talking about families losing land they've tilled for generations because they couldn't produce a specific piece of paper from, say, 1950.
I see why you might frame it as a burden, specifically from the perspective of a frustrated applicant. But I view it as a crucial safeguard. The central question we are debating today is exactly this. Does the historical presumption of state ownership place an unreasonable burden on private individuals? Or is it a necessary safeguard for the nation's patrimony?
Exactly.
To answer this, we really have to look at the strict jurisprudence of Republic v. Tan properties and then contrast it with the recent legislative attempt to soften those edges through Republic Act 11573. I am arguing that the strict interpretation, specifically the requirement for rigorous proof like the twin certifications, is absolutely essential to protect the public domain from illegal encroachment.
And I come at it from a different way. I will be arguing that the pragmatic approach introduced by RA 11573 is not just welcome, but entirely necessary to save the land registration system from collapsing under its own weight. The substantial compliance standard is the only fair way to navigate a system where government records are often incomplete, burned, or missing.
Well, let's begin by establishing the baseline, because without this context, the rest of the debate just floats in a vacuum.
Sure.
The core of this issue is Article 12, Section 2 of the 1987 Constitution. It states clearly that with the exception of agricultural lands, all other natural resources shall not be alienated. Now, alienated here is the key legal term. It means transferred to private ownership.
Transferred out of the public domain.
Right. The default setting of our legal system is that the state owns everything. As Justice Sanchez famously put it, the standing presumption we must not forget is that land pertains to the state. This isn't just a legal nicety or a suggestion, it is the starting line. Any person seeking to establish ownership must conclusively must provide incontrovertible evidence that they are the owner and that the state has actively released that land.
I don't dispute the constitutional basis at all. Jura regalia is the law of the land. However, we have to look at the practical application of that default setting. You mentioned incontrovertible evidence.
I did.
In the real world, for a regular applicant seeking judicial confirmation of an imperfect title, that phrase translates to a nightmare. You're asking for proof of a positive act of government. That means a presidential proclamation, an executive order, or a legislative act. But often, the agencies charged with keeping these records don't even have them organized.
That is a bold claim against the agencies.
But it is historically accurate. The doctrine assumes a perfectly functioning bureaucracy which, historically, simply hasn't existed. You are effectively asking citizens to be better at record-keeping than the government itself.
I'm not convinced by that line of reasoning because it conflates difficulty with injustice. The bar is set high because the stakes are incredibly high. Once land leaves the public domain, it is gone from the state's control forever. It can be sold, subdivided, commercially developed, or destroyed. That is exactly why the Supreme Court in the landmark case, Republic versus TAN Properties, drew a line in the sand.
But that line was drawn so rigidly.
They held that it is not enough for a local community environment and natural resources officer, or CNRO, to simply certify that land is disposable. Why? Because a local officer does not have the authority to classify land. Only the DNER secretary does. If we lower that bar, we invite corruption. Imagine a local officer being bribed to certify a protected forest as agricultural land. The strict rule prevents that.
I hear your point on corruption, but strict adherence to TAN properties created a trap for thousands of legitimate claimants. You're referring to the requirement where an applicant needs the original classification order approved by the DNR secretary. But let's be honest about what that looks like on the ground.
Go ahead.
An applicant in a remote province has to secure a certified true copy of a classification order that might sit in a dusty archive in Manila, signed decades ago. In many cases, the CENRO, the local office, says, yes, this is alienable, but the applicant loses the court case because they didn't have the secretary's original memo. The Supreme Court itself recognized this harshness. That's why we saw rulings like Republic versus Vega and Republic versus Serrano, where the court essentially said, this is too much.
That's an interesting point, though I would frame those cases quite differently. Vega and Serrano were not abandonments of the rule. They were pro hoc vice rulings.
For this occasion only.
Exactly, meaning for that specific occasion only. The court recognized that TAN Properties was promulgated on June 26, 2008. The applicants in Vega and Serrano had filed their cases before that date. They literally had no opportunity to comply with the new strict judicial standard of the twin certifications.
Which proves my point about the standard being an abrupt hurdle.
But the court was very clear. The strict rule remains. The exception was only for those caught in the transition. It did not invalidate the need for the twin certifications going forward. It was a mercy for those blindsided by a change in jurisprudence, not a change in the law itself.
I understand the legal distinction of pro hoc vice, but I think it reveals a deeper flaw in the strict constructionist view. If the Supreme Court had to carve out exceptions because the rule was too harsh to apply retroactively, it suggests the rule itself might be disconnected from the reality on the ground. And this brings us to the core of our debate regarding those twin certifications. This requirement was the specific mechanism that broke the system for so many people.
Let's dig into the twin certifications then, to make sure the audience understands exactly what we are arguing about. Derived from TAN Properties, an applicant needs two specific documents to overcome the presumption of state ownership. Letter A, a copy of the original classification approved by the DENR secretary or the president, certified as a true copy by the legal custodian.
Right.
And letter B, a certificate of land classification status issued by the CENRO or PENRO. Now, my argument is that this redundancy is vital. A CENRO certification alone is insufficient because, as I mentioned, They lack authority. They are implementing officers, not policymakers. If we allow local officers to alienate public land without the backing of the Secretary's original order, we open the door to massive error and local graft.
I have to push back on that. Redundancy is a polite word for impossible bureaucracy. Let me tell you why that paralyzed the system. You are demanding a specific document, the original classification order, that might be buried in the archives of the national government, effectively inaccessible to a farmer in Mindanao or northern Luzon.
It is the burden of proof.
And here is the kicker. Sometimes the local Senero certification says the land is alienable and disposable, but the applicant cannot find the specific forestry administrative order number because the records from the 1930s or 40s are incomplete. So the land is disposable, everyone locally knows it is, the local government treats it as such, but because a piece of paper is missing in Manila, the state reclaims it. That is unjust.
It is the strict application of jura regalia.
Which is exactly why the shift toward Republic Act 1157-3 is so critical. The legislature finally stepped in to say, we need a system that relies on available technical data, not just a treasure hunt for old papers. RA 1157-3 moves us toward substantial compliance as the standard, not just a rare exception.
But does it? Or does it simply change the form of the proof to something significantly less reliable? I worry that RA 1157-3 might be swinging the pendulum entirely too far. Let's look at the role of NAMRIA.
The National Mapping and Resource Information Authority.
Yes. Historically, the Supreme Court has been very skeptical of NAMRIA certifications. In fact, there is jurisprudence stating clearly that NAMRIA is not among the agencies authorized to certify land classification. Their job is cartography, not law. They are map makers. The court ruled that relying on a NAMRIA certification was an error because it wasn't authoritative evidence of a positive act by the government. Just because a map is colored green or yellow doesn't mean the president signed a decree.
That is exactly the precedent that RA 11573 corrects. This is the pivot point in the law. Under the new framework, specifically Section 7, the legislature has explicitly empowered the use of NAMRIA records. It acknowledges the reality that sometimes you simply cannot find the specific forestry administrative order or executive order.
And so they look to the maps.
Yes. In those cases, the law now says it is sufficient to cite the land classification map number, the LC map number existing in NAMRIA's inventory. This is huge. It transforms the map from a mere picture into legal proof. It acknowledges that the map reflects the legal reality, even if the underlying statute is missing from the file cabinet.
I see why you think that solves the administrative problem, but look closely at what that implies legally. You are substituting a legal decree, an executive order, with a technical inventory number. The law says that if the order is unavailable, a sworn statement citing the map number and the date of release indicated on the map is sufficient. My concern is that we are effectively allowing the map to become the law. Maps have errors. Cartographers make mistakes.
Human error exists everywhere, including in legal drafting.
True. But if the map has an error, does that error now become the basis for alienating public land? We are moving from incontrovertible evidence of a state's will to a reliance on technical data storage. You are essentially trusting the IT department over the legal department.
That's a compelling soundbite, trusting IT over legal, but have you considered the alternative? The alternative is that land which has been treated as alienable for decades, which appears on the government's own master maps as alienable, remains in legal limbo because a specific piece of paper from 1950 cannot be located.
The burden is on the applicant to prove it isn't in limbo.
But RA 11573 doesn't abandon the need for proof. It changes the source of the proof to something verifiable and accessible today. It pivots the system from exclusion based on missing bureaucracy to inclusion based on available technical data. And let's be clear about NAMRIA. They are the central mapping agency of the government. If we can't trust the government's own master maps, we have bigger problems than land titling.
Let's talk about the specific mechanism of this new proof, because this is where my hesitation regarding the safeguard aspect really deepens. We are discussing Section 7 of RA 1153. Previously, under TAN properties, we needed the imprimatur of the DNER secretary. a cabinet-level official, the alter ego of the president. Now, the law allows a duly designated geodetic engineer to sign a certification.
Yes, and it is a brilliant streamlining of the process.
Is it? Or is it a dangerous delegation of state authority? The law states that a duly signed certification by a duly designated geodetic engineer, imprinted in the approved survey plan, is now sufficient proof. We have gone from the cabinet secretary to a geodetic engineer. That is a massive step down in the hierarchy of authority.
I wouldn't call it a step down. I'd call it specialization.
Can we really say the state's patrimony is secure when the positive act of the government is verified by a private technical professional rather than a high-ranking official? Geodetic engineers are hired by the applicant. There is an inherent conflict of interest there that didn't exist when we required the secretary's signature. The engineer gets paid if the survey plan is approved.
You are framing it as if the geodetic engineer is acting in a total vacuum, scribbling on a blueprint in a coffee shop and handing out titles. That is simply not the case. The implementing rules and regulations are very specific about how this works. This isn't just any engineer acting alone. The survey plan must be approved by the Land Management Bureau, specifically by the chief of the Mapping and Survey Division.
But the engineer starts the process.
The engineer is authorized by that division chief. The engineer is essentially the conduit for the data, but the official approval still comes from the Bureau.
But the certification itself, the sworn statement, is made by the engineer. If the engineer lies or is negligent, the survey plan gets approved with false information.
Correct. But look at what they are actually certifying. They are certifying that the land falls within a specific project number and map number. They are essentially translating the complex data of the NAMRIA maps onto the survey plan so the court can easily read it. The law requires this certification to be imprinted on the plan. It must state the applicable administrative order or proclamation.
And if that order is missing?
If that order is missing, as we discussed, they cite the LC map in NAMRIA's inventory. It effectively merges the technical survey with the legal classification status into one single document. It's efficiency, not negligence. And regarding your fear of lying engineers, they are licensed professionals whose careers are on the line. If they falsify a material fact on a sworn statement, they face severe criminal liability. That is a highly significant deterrent.
Efficiency often comes at the cost of scrutiny. Under the TAN standard, the twin certifications required 2 independent confirmations. You had the original order from the central government and the local status from the local government. Now we are consolidating this into a single imprinted certification on a survey plan. The implementing rules even describe these as simple certifications.
Simple doesn't mean inaccurate.
My fear is that by simplifying the certification, we are simplifying the scrutiny. The concept of juro regalia presumes that the state holds the land until it explicitly lets it go. If we make it too easy to prove the state let it go by relying on a map reference instead of a formal decree, are we eroding the doctrine itself? Are we slowly privatizing the public domain by default?
I firmly disagree that we are eroding the doctrine. We are modernizing it. The doctrine of juro regalia was never meant to be a weapon against the nation's own citizens. It was meant to protect resources from foreign interests or unfettered corporate exploitation. But when the protection becomes a prohibition due to administrative failure, the law must evolve.
It's an evolution of convenience.
RA 1157-3 accepts that if the government's own mapping agency, NAMRIA, says the land is alienable, and the Land Management Bureau approves the survey plan, that should be enough. We are moving from a system of gotcha technicalities to a system of substantial compliance as the norm. It recognizes that the state has a duty to its citizens to facilitate distinct ownership, not just to hoard title indefinitely.
Substantial compliance was used in Vega and Serrano because the applicants were entirely blindsided by a sudden judicial shift. Now, you are making substantial compliance the standard operating procedure. I suppose my reservation comes back to the source of the right. The state is the source of all land rights. When we allow a geodetic engineer's sworn statement to substitute for the secretary's direct approval, we are placing a tremendous amount of trust in the technical accuracy of that engineer and the digital inventory of NAMRIA.
Yes, we are.
And let's be honest, government databases are not immune to hacking, alteration, or simple data entry errors. A typo in a map number could cost the state hundreds of hectares of forest land.
And that is exactly where trust should lie in a modern system, in the technical experts and the official records, not in the ability of an applicant to navigate a bureaucratic archive from a century ago. You worry about a typo? I worry about the thousands of cases clogging our courts where the land is clearly private in character, occupied for 50 years, but the title is denied because the DNR can't find a file from 1955.
The courts are clogged, yes.
The engineer must make a sworn statement. There is accountability there. If they lie or falsify the LC map number, they are liable. It's not a free-for-all. It is a structured technical method of proof that replaces a cumbersome paper chase method of proof.
I will concede that the twin certifications were a high hurdle, perhaps too high for the average farmer without significant legal representation. However, the rigor of TAN properties ensured that no land was lost to the public domain without the highest level of verification. While RA 11573 simplifies this, we must remain vigilant.
I agree with vigilance.
The requirement to cite specific data, the LC map number, the project number, the date of release, means that the presumption of state ownership is still only overcome by specific, verifiable evidence. It is not a waiver of the doctrine. It is just a different form of evidence.
Exactly. We haven't abandoned the need for evidence at all. We've just clarified what constitutes valid evidence in the 21st century. The shift from the twin certifications to the imprinted certification represents a maturity in our land laws. It balances the Regalian Doctrine with the reality of available records. It acknowledges that if the government's own maps say the land is yours, you shouldn't be penalized because the government lost the original memo.
It is certainly a brave new world for land registration. The pendulum has swung from the strict protectionism of TAN properties towards the facilitation of RA 1157.3. Whether this new balance adequately protects the public domain while serving private rights is something that will likely be tested in future Supreme Court decisions. If we start seeing protected forests titled because of substantial compliance, the pendulum may very well swing back.
Or we might finally see a backlog of legitimate titles cleared, allowing families to finally own the land they live on. Complexity often requires multiple perspectives to fully appreciate, and in land law, the tension between state protection and private rights is eternal. We've moved from an impossible burden to a manageable one, and I think that is a victory for the rule of law.
A manageable burden, provided the maps are accurate. As always, the devil is in the details, or in this case, in the imprint on the survey plan. That brings us to the end of today's analysis. There is certainly more to explore in the application of these new guidelines.
It's been a fascinating look at how a single statute can reshape decades of legal presumption.
We will leave it there for today.
Discuss the Regalian Doctrine and its legal consequences regarding land ownership.
Under the Regalian Doctrine, which is embodied in Section 2, Article 12 of the 1987 Constitution, all lands of the public domain belong to the state, which is the source of any asserted right to ownership of land. With the exception of agricultural lands, all other natural resources shall not be alienated. So again, all lands not appearing to be clearly within private ownership are presumed to belong to the state unless public land is shown to have been reclassified or alienated to a private person by the state. It remains part of the inalienable public domain. As expressed by Justice Sanchez, the standing presumption, we must not forget, is that land pertains to the state, and any person seeking to establish ownership over land must conclusively show that he is the owner, pursuant to the Regalian Doctrine, or Jura Regalia, a legal concept first introduced into the country from the West by Spain through the laws of the Indies and the royal cedulas. All lands of the public domain belong to the state. This means that the state is the source of any asserted right to ownership of land and is charged with the conservation of such patrimony. All lands not appearing to be clearly under private ownership are presumed to belong to the state. Also, public land remains part of the inalienable land of the public domain unless the state is shown to have reclassified or alienated them to private persons.
How is the alienable and disposable character of lands of the public domain proved?
To overcome the presumption of state ownership of lands, incontrovertible evidence must be established that the land subject of the application is alienable or disposable. To prove that the land subject of an application for registration is alienable, an applicant must establish the existence of a positive act of the government, such as a presidential proclamation or an executive order, an administrative action, investigation reports of the Bureau of Lands investigators, and a legislative act or a statute. The applicant may also secure a certification from the government that the lands applied for are alienable and disposable. In the case of Republic versus TAN Properties Incorporated, the Supreme Court held that it is not enough for the PENRO or SENRO to certify that a land is alienable and disposable. The applicant for land registration must prove that the DNR secretary had approved the land classification and released the land of the public domain as alienable and disposable, and that the land subject of the application for registration falls within the approved area for verification through survey by the PENRO or SENRO. In addition, the applicant for land registration must present a copy of the original classification approved by the DNR Secretary and certified as a true copy by the legal custodian of the official records. These facts must be established to prove that the land is alienable and disposable. The Supreme Court interpreted this doctrine as embodying a requirement of twin certifications consisting of letter A copy of the original classification approved by the DNR Secretary or the President and certified as a true copy by the legal custodian of the official records, and letter B, a certificate of land classification status issued by the SENRO or PENRO and approved by the DNR Secretary. Until recently, if a case reached the Supreme Court after the promulgation of the TAN Properties case, it allowed the application of substantial compliance because there was no opportunity for the registrant to comply with the ruling in the TAN Properties case. The trial court and the Court of Appeals already having decided the case prior to the promulgation of the TAN Properties case. Thus, in light of jurisprudence, a SENRO or PENRO certification alone is insufficient to prove the alienable and disposable nature of the land sought to be registered. It is the original classification by the DNR Secretary or the President which is essential to prove that the land is indeed alienable and disposable. It must be pointed out, however, that despite the stringent rule held in Republic versus TAN Properties Incorporated, that the absence of the twin certifications justifies the denial of an application for registration, subsequent rulings of the Supreme Court in Republic versus Vega and Republic versus Serrano allowed the approval of the application based on substantial compliance. Even so, Vega and Serrano were mere pro hac vice rulings and did not in any way abandon nor modify the rule on strict compliance pronounced in TAN Properties. Where the trial court rendered its decision on the application prior to June 26, 2008, the date of promulgation of TAN Properties, the applicant cannot be required to comply with the strict rules laid down therein, as it had no opportunity to comply with its twin twin certification requirements. In another case, the Supreme Court held that the DNR NAMRIA certification that respondents filed with their application failed to meet the requirement, for NAMRIA is not among the agencies of DNR authorized to certify on land classifications. It even lacked the authority to issue a copy of such certification, the Supreme Court added. And so the Supreme Court ruled that the Court of Appeals erred in relying upon the DNR NAMRIA certification, as it is not authoritative evidence of the alienable and disposable classification of the lot involved in the case when the application for registration was filed. Nevertheless, the Supreme Court added that DNR orders and resolutions of the Office of the President per se are undoubtedly authoritative pronouncements of the alienable and disposable classification of the lot involved. They were rendered by the proper authorities that can decide on the classification of public lands and the alienability and disposability thereof through public auction. Recently, a law has been enacted that specifically established the requirement for proving the alienable and disposable character of the land involved in an application for judicial confirmation of imperfect titles to alienable and disposable lands of the public domain. According to Republic Act 11573, Section 7, first paragraph, for purposes of judicial confirmation of imperfect titles filed under Presidential Decree number 1529, a duly signed certification by a duly designated DNR geodetic engineer that the land is part of alienable and disposable agricultural lands of the public domain is sufficient proof that the land is alienable. The said certification shall be imprinted in the approved survey plan submitted by the applicant in the land registration court. The imprinted certification in the plan shall contain a sworn statement by the geodetic engineer that the land is within the alienable and disposable lands of the public domain, and shall state the applicable forestry administrative order, DNR administrative order, executive order, proclamations, and the land classification project map number covering the subject land. Should there be no available copy of the forestry administrative order, executive order, or proclamation, it is sufficient that the land classification, LC map number, project number, and date of release indicated in the land classification map be stated in the sworn statement declaring that said land classification map is existing in the inventory of LC map records of the National Mapping and Resource Information Authority, NAMRIA, and is being used by the DNR as land classification map.
How are the provisions of Section 7, Republic Act numbered 11573, carried into effect by its implementing rules and regulations?
One of the things that one prepares if one undertakes to apply for registration of title to alienable and disposable lands of the public domain is a survey of the land. That survey is to be approved by the Lands Management Bureau, in particular by the section or division thereof and charged with mapping and surveys. The implementing rules for Republic Act 11573 indicates the chief of such mapping and survey division of the Lands Management Bureau as the geodetic engineer duly authorized to sign the required certification that the land is alienable and disposable in character. And this certification is to be imprinted upon the survey plan itself, as required by Republic Act 11573. So the approved survey plan would have an imprint of that certification. Now, the imprinted certification would then be in the form of sworn statement by that geodetic engineer that the land is within the alienable and disposable lands of the public domain. with statement regarding the applicable Forestry Administrative Order, DNR Administrative Order, Executive Order, Proclamation, and Land Classification Map Number covering the subject land. Now, if there are no available copy of the Forestry Administrative Order, Executive Order, or Proclamation, Section 7 of Republic Act 11573 would accept a sufficient certification that the land classification map indicated in the land classification map via a sworn statement that the land classification map is existing in the inventory of land classification map of the National Mapping and Resource Information Authority of the NAMRIA. Although this may sound complicated, it is not so. If one takes a look at the implementing regulation, the specific certifications that are being mentioned for purposes of proving the alienable and disposable character of the land involved consists of very simple statements referred to in the implementing regulation either as Annex I or Annex J. These are very simple certifications.